We'll discuss on the important topics PAS-6 because now it is the season for filing PAS-6. The due date is 30th of this month, 30th of May. What is PAS-6? PAS-6 is the half-yearly reconciliation of share capital audit reports that unlisted public companies, because listed companies not required to file, unlisted public companies and certain private companies must file with the register of companies. So PAS-6 has to be filed by unlisted public companies and certain private companies. Its primary purpose is to reconcile the total number of shares held in both dematerialized and physical form with the issued capital of the company. So which companies are required to file PAS-6? Initially, you all know very well that Rule 9A of the company's Prospectus and Allotment of Securities Rule 2014. As per 9A, initially the filing of PAS-6 was mandated for unlisted public companies. Then later, certain private companies are required to file. Rule 9B. Introduction of Rule 9B through the company's Prospectus and Allotment of Securities, Second Amendment Rules 2023. So the requirement has been extended to private companies, excluding small companies. Because now the due date for a dematerialization of private companies is extended to 30th June 2025. Are there any exemptions for filing of PAS-6? Yes, there are certain exemptions. Nidhi companies are not required to file PAS-6. Government companies are not required to file PAS-6. So, what is Nidhi company? Companies formed to cultivate the habit of thrift and saving among their members. Government companies, companies which is not less than 51% of paid-up capital, held by central government, any state government, or jointly by central government and one or more state governments. So, Nidhi companies are exempted for filing of PAS-6. Government companies are exempted for filing of PAS-6. And only one subsidiary of public company. So, companies where the entire share capital is held by another company, that is called holding company. This is what Rule 9A. After Rule 9B, then even private companies, small companies are exempted. So, we'll discuss. What are the dates for filing Form PAS-6? PAS-6 must be filed within 60 days from the conclusion of each half year, because the form is half yearly basis. For the period of April to September. April to September, due date is 29th November. And for the period 1st October to 31st March, due date is 30th May. So now, on or before 30th May, we need to file PAS-6. So what information is required in the form PAS-6? Company details. So like company name, SIN number, registered office address. So pre-fill, once you enter the SIN number or company name, it will get pre-filled this registered office address. Then ISIN details are important. This is a base. ISIN stands for International Securities Identification Number for each type of security. Then share capital details, total issued capital, number of shares held in Demat, shares held in physical form, and any change in the share capital during the year or during the 6 months, details of any changes during the half year, either through rights issue, bonus issue. So, details of promoters, directors, and KMPs, whether their shares are in Demat or physical form. These are the details required while filling the form. And certification, it must be certified by either practicing company secretary or chartered accountant. Only these two professionals. What are the penalties for non-compliance? Yes, non-compliance will attract penalties. Company one-time penalty of 10,000 and 1,000 per day, subject to maximum of 2 lakh. An officer in default, 1,000 rupees per day of default, subject to maximum of 50,000 rupees. Obtaining ISIN is mandatory for filing form PAS-6, because without ISIN you cannot proceed filing of form PAS-6. A company cannot proceed with the filing of PAS-6 without ISIN for each type of security. Can a company issue shares in physical form? As per 9A of the Companies Act, Companies Prospectus and Allotment of Securities Rules 2014, companies are required to issue securities only in Demat form. Public companies and for private companies, yes, time is extended up to for a dematerialization. Dematerialization time is extended for certain private companies. The last date is 30th June 2025. Form PA-6 applicable to private companies? Yes. With the introduction of Rule 9B, private companies excluding small companies now required to file Form PA-6. So for further details, we can visit Ministry of Corporate Affairs. Just I will show you the official website of Ministry of Corporate Affairs. I will show you the form. We will close, stop sharing. Then I will take you to official websites. Go to MCA, Ministry of Corporate Affairs. This is Ministry of Corporate Affairs. MCA services. Here company e-filing. Then you have to go to compliance service. Because this is a compliance service, so you have to go to compliance service. Again, I will show you MCA services, company e-filing, and then compliance services. Here compliance services, if you see, here the forms are given PA-6. This is the PA-6. Reconciliation of share capital audits. This is form PA-6. This is a corporate identification number. If you put SIN number here, then you have to prefill. Company name will come here. The name of the company, address, and email ID of the company. Then period of filing. Because the form is required 6 months once. So 1st October 2024 to 31/3/2025. The number of class of shares. Then type of security, equity preference. Each class of shares ISIN required. Here we have to mention. Then held Demat, either CDSL or NSDL. So held dematerialization from CDSL, number of shares held in CDSL, percentage. Number of shares held in NSDL and percentage. Held in physical form and percentage. And total number of shares. So you should tally with the issued capital. So if any physical shares are there, the reason has to be mentioned here. Any change during the 6 months. So number of shares beginning of the reporting period. Here number of shares, whether in NSDL or CDSL, we need to mention. Then if any change through rights issue or bonus issue or private placement, ESOPs, amalgamation, conversion, buyback, capital reduction, forfeiture, any other, please specify and give the details. NSDL and CDSL number of shares held. So any change because of the either because of the any of the corporate actions, rights issue or bonus issue or private placement or ESOPs, amalgamation, conversion. So all these details needs to be filled. And number of shares at the end of the reporting period. These are all changes during the period. Beginning the period, number of shares changes during the 6 months, and number of shares at the end of the reporting period needs to be filled. Then details of the shares held by the promoters, directors, KMPs, physical and total, and Demat. So these number needs to be mentioned. Then whether the register of members is updated, yes. Then details of Demat request. So any request received from shareholders and confirmed after 21 days, pending more than 21 days. So these details has to be, and with the reason has to be mentioned here. Number of requests received, number of shares, and reasons for delay, if at all. Then whether there is appointment of common agency for the share registry work, RTI is appointed, yes, and give the name. Any other details that the professional signing of this form may like to provide, then yes, details can be given. Then save and go to next. Then certificate column will be there. Then after that, upload the form. Then fill the details, certification details. Then DSC. Then again download and upload the form and pay the fee. This is what the form PA-6. And if we come back to rules, I'll show you the rule also, rule 9A and rule 9B. Here, how to see the rules. If you click here, then here rules will come. Now we are talking about company's prospectus and allotment of securities rule 2014. If you click here, here you can see rule 9A and rule 9B. I'll show you rule 9B, issue of securities dematerialized from by, this is for private companies. So now dematerialization time is there up to 30th June. Here it is mentioned. So 9B, issue of securities in dematerialized form by private companies. Public companies already rule 9A is there. So a very private company other than small company. So small companies are exempted. Within the period referred in subclass 2, now the extension has given up to 30th June 2025. So issue securities in dematerialized form. Facilitate dematerialization for all securities. So company has to facilitate means company has to obtain ISIN number in accordance with the provisions of the Depositories Act. Depositories we have CDSL and SDL, two depositories. So a private company which has a last day of financial year ending on or after 31 March 2023, because this notification has come, so the base has taken as on 31 March 2023, is not a small company. So small company definition we know 4 crores and 40 crores, capital 4 crores and turnover 40 crores. It crosses, either of the one crosses, then it is not the small company. So small company means made up capital shall be within 4 crores and turnover within 40 crores. So as per the audited financial statement, as on 31 March, shall within 18 months from the closure of such financial year comply with the provisions of this rule. Anyway, the last date is 30th June for private companies. Small companies are exempted, and even producer company covered under this sub rule shall within a period of 5 years of closure of such financial year comply with these provisions of this rule. This is what the facility given for producer companies also. So private company other than a producer company which is not a small company as of 31 March 2023 may comply with the provisions of this sub rule by 30th June 2025. This is the last date for Demat. So a very private company making it as referred in sub rule 2 just we have discussed, making any offer for issue of any securities or buyback of securities or issue of bonus shares or rights offer other than the date when it is required to comply with this rule shall ensure that before making such offer, entire holding of securities of promoters, directors, KMPs has been dematerialized in accordance with the provisions of the Depositories Act. First, ISIN facility has to be given to all shareholders, but the company cannot force the shareholders to do it immediately. So first, promoters, directors, and KMPs has to complete their dematerialization. So every holder of securities of the private company referred in sub-rule 2 who intends to transfer of such securities, even shareholder wants to transfer the securities after this date is a mandatory, otherwise transfer cannot be done. After the due date when the company is required to comply with this rule shall get the securities dematerialized before the transfer. Who subscribes to any securities of the concerned private company, whether by way of private placement or bonuses or rights issue, or after the date when the company is required to comply with this rule, shall ensure that all the securities are held in Demat before such subscription. So anyway, rule 9A is for public companies. It is already, we all know, this is for private companies, certain private companies, rule 9B. Hope you are clear. Thank you. This is what about PAS-6.